Hello and Namaste. I am Ketan Kank from 19.2 Consulting. In the series of question and answers, the next question that has come in front of me is: my father-in-law had shares in various companies. My wife also expired a few months ago. Can I get those shares? So first of all, the question arises whether your father-in-law is alive today or not. So if your father-in-law is alive, he can simply make a will and he can get the shares reclaimed in his name and then get it transferred to your name. Then there is no problem. But if your father-in-law is deceased and your wife is also deceased and the shares have gone to IPF, then the first claimant would be the direct legal heirs of your father-in-law. In case you have got a brother-in-law, in case you've got a sister-in-law, in case your mother-in-law is alive, those would be the first persons who would be the claimant of the shares. And despite of them, you want those shares and those people are have no objection in you getting those shares, then my advice to you would be get the shares reclaimed in their direct legal heirs name and then transferred to your name. That way, the shares will be reclaimed in the legitimate form to their direct legal heirs and they can be further legally transferred to you. So that is one way. But if none of them are alive, only if your father-in-law had shares, in the worst case scenario, if you think if their father-in-law is also deceased and apart from your wife there were no other legal heirs to the shares, then it has to be established in front of all the legal authorities such as the company, the RTA and the court that you are the lawful claimant to those shares. And only if it is admitted beyond doubt that there would be no objection from any of the stakeholders in you getting those shares, then yes, you can get. But there is a legal procedure to be followed before doing all these things, and I advise you to follow the legal procedure before getting into the reclaiming of the shares. Second question today is: what is demerger? Do the existing shareholders get additional shares in case of demerger? Okay, so to understand the concept of demerger, let us first reflect upon the concept of merger. So merger is two entities coming together and one of the entity dissolving and getting merged into another entity. So if company A and company B gets merged with each other, then one of the company ceases to exist and a third entity is formed. But in case of demerger, the business is shelved out. So if company A has got multiple businesses and if the board decides that a particular business should be operated by way of separate legal entity, then for the operation of that particular business, a separate entity is formed and that business is carried under that entity, which is called as demerger of entities. So demerger is nothing but a particular business getting out from the company and being carried out by a separate legal entity or a separate legal company. Next sub question in this question is that whether the existing shareholders of the company get shares in the demerged entity. To whatever research I have done till today, in most of the cases, the existing shareholders do get shares in the demerged entity because while investing into the shares of the original company, they had contemplated about all the businesses carried under the initial entity. And if a particular entity is getting demerged from the main entity, then most of the cases the shareholders get the shares. But there are some instances wherein the shareholders are also given exit route while demerging the company or while the demerger exercise is on. So if the shareholders take that exit route, then there is no question of the shareholders getting the shares in the demerged entity. So it all depends how the plan of demerger is being drafted and approved by the National Company Law Tribunal or other legal authorities. So it is not mandatory that the shareholders will get the shares in the demerged entity, but yes, in most of the cases, the board of directors and the legal authorities see to it that while doing these mergers, acquisitions or demergers, the shareholders don't get exploited or they don't suffer. Should you have any queries relating to the shares or reclaiming of the shares or the concepts related to reclaiming of the shares, you may feel free to get back to us. You can revert or you can write to us on info@19.2.in or you can simply mark your comments in the comment section of this video. We will get back and we will be all the more happy to help. Till then, this is Ketan signing off. Thank you so much.